Regents of the University of California versus Bakke, the 1978 case that changed affirmative action. Following the civil rights movement, universities across the United States adopted affirmative action programs. These were designed to increase opportunities for historically underrepresented students in higher education. The goal was to address past discrimination and foster diversity. However, these programs soon faced legal challenges that would reach the highest court in the land. In the early 1970s, the UC Davis School of Medicine reserved 16 out of 100 seats for minority applicants. Alan Bakke, a white applicant with high test scores, was rejected twice. Bakke argued that the admissions program violated the Equal Protection Clause of the 14th Amendment because it considered race as the deciding factor for those reserved spots. The central issue was clear. Can a public university consider race in its admissions process under the Equal Protection Clause? The Supreme Court had to decide if promoting diversity was a compelling enough interest to justify the use of race. The court turned to the 14th Amendment, which guarantees that no state shall deny any person within its jurisdiction the equal protection of the laws. This clause is the bedrock of civil rights law, requiring the government to treat similarly situated individuals in a similar manner. The result was a landmark split decision. Justice Lewis Powell delivered the opinion of the court, which offered a nuanced middle ground. The court held that while universities may consider race as one factor among many to achieve diversity, rigid racial quotas are a violation of the Constitution. The court recognized that educational diversity is indeed a compelling governmental interest. However, the means used to achieve it must be narrowly tailored. Admissions must be individualized. Race can be a plus factor, but it cannot be the sole basis for insulating an applicant from comparison with all others. Bakke became the foundation for decades of university admissions policies. It established the diversity rationale that would be tested in future cases for nearly 50 years. The debate over affirmative action continued until 2023, when the court eventually moved away from the precedent Bakke had established. The rule to remember from Bakke is this: race may be considered as one factor in admissions, but rigid racial quotas violate the Equal Protection Clause. Follow Legal Tech AI for more landmark cases, law school content, and bar exam preparation. Legal intelligence powered by AI.